A beloved Jacksonville Teacher of the Year, Mitchell Patch, and his one-year-old son Everett were killed in a devastating crash while crossing a busy street. And now, after 6 months of investigation, the driver, 24-year-old Logan Fletcher Park, has finally been charged. Police say Park was speeding, impaired, and the impact was so severe that both victims were thrown hundreds of feet away. We are going to break down the shocking details, the allegations, the potential criminal defense, and more with a criminal defense attorney and former prosecutor. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Real quick, let me say this. Do you know why we can cover an important story like this? It's because of the support that we get from Morgan & Morgan, our sponsor. I'm talking about America's largest personal injury law firm. I'm talking about a firm with over 1,000 attorneys who have recovered $25 billion for more than 500,000 clients. In fact, in the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. In Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. And Morgan & Morgan, they make it so easy to fight for what you deserve. You can start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/LC Sidebar. You can click the link below, or you can scan the QR code on screen. We are digging into a case that has shaken the Jacksonville community for months. It is a heartbreaking crash that killed a beloved elementary school teacher named Mitchell Patch and his one-year-old son Everett. And this as they were simply crossing Bay Meadows Road in Florida on a Friday night. Police say the two were just crossing this roadway when a car came barreling through the intersection and struck them both. Both were confirmed dead at the scene. Now, Mitchell wasn't just a father, he wasn't just a husband. He was a math teacher at Bayview Elementary, and the impact of his loss rippled through the whole school almost immediately. The principal, Kelly York, sent a message to families the next day, writing, "We will all certainly remember Mr. Patch for his incredible commitment to students and to the teaching profession. He was a dedicated educator and well-loved and respected member of our brave family. Our sympathies go out to Mr. Patch's family, friends, and our entire school community during this difficult time. I am deeply saddened, and I know the students, staff, and family members who knew Mr. Patch will miss him tremendously." Now, here's the thing. From an investigative and legal point of view, for months, investigators stayed quiet publicly. No one was arrested. The community didn't know whether this was a tragic accident, whether it was reckless driving, whether it was something more. So what exactly happened? Why no charges right away? Well, after nearly 6 months, police say the driver, identified by them as 24-year-old Logan Fletcher Park, has finally turned himself in after a warrant was issued for his arrest. Now, to be clear, he's innocent until proven guilty. And that's what we're going to explore, what his defenses may be, what the evidence is. And here's the thing, we have obtained the full booking report, and it lays out what authorities are alleging, what the state's potential case could look like. And I will tell you, this is in stark and detailed and graphic terms. And the most stunning part, investigators say that the impact was so severe that I will get into what happened to Mitchell and Everett's bodies, but also they were apparently thrown more than 200 feet. And the evidence calculations suggest that Park was driving almost 20 miles per hour over the limit with a blood alcohol content of 0.107. That is well over the legal limit of 0.08. But again, his blood was drawn that night, so why the arrest so long after? What were they doing? That's what we're going to discuss. So let's walk through exactly what happened in the case from the very beginning, because if you're just now hearing about it, the timeline is very, very important here, and it explains why this has become such a big point of conversation, particularly in Jacksonville. According to the booking report, this all goes back to May 16th. It was a Friday evening, and Mitchell Patch, again a teacher who, according to the Florida Times-Union, had previously won the Teacher of the Year award, was leaving a gathering with his one-year-old son Everett and was crossing on Bay Meadows Road. That is when police claim a car traveling on the street struck them both, killing them. Meanwhile, the driver, in this case the supposed driver, who police believe to be Logan Fletcher Park, stayed on scene, and officers conducted their standard on-scene investigation. They collected physical evidence, they documented the crash layout, they interviewed the driver, but ultimately they didn't take him into custody. No, instead he was taken to a hospital for treatment. And through the summer, police repeatedly confirmed that the investigation was ongoing, that it was active, but they really shared almost nothing publicly about what was going on behind the scenes. And then, almost 6 months after the crash, everything shifts. According to a release from the Jacksonville Sheriff's Office on November 9th, after police obtained a warrant for his arrest, police say 24-year-old Logan Fletcher Park turned himself in. According to his court docket, he was formally charged with 2 counts of DUI manslaughter, and his bond was set at $50,000. And the moment those charges were filed, the booking report was released, and it reveals exactly what investigators claim they found over the course of that 6-month investigation. So to help break this down, I want to welcome back on criminal defense attorney and former prosecutor Michael Brown. Michael, thank you so much for taking the time. It's good to see you.
Same here, Jess. Pleasure to be here.
From your experience, right, from your experience on both sides, is it unusual to see a fatal crash with no immediate arrest on scene, especially when 2 people have died, when the person that they know who was a part of the crash or allegedly part of the crash, person's taken to the hospital? Is it strange to not see an immediate arrest?
It's very strange. You know, if for nothing else, at least you would see the arrest for the driving while intoxicated charge. So, and then oftentimes the homicide charge will come after the fact once they have a blood alcohol level or they continue to do further investigation. But the immediacy, for the most part, I always see an arrest on the driving while intoxicated charge.
I will get into what they might have been doing and maybe what the delay was. But is it also unusual to you, maybe not, that investigators, they can stay pretty tight-lipped during a crash investigation like this? Why the silence?
Yeah, I do think it's important to keep it tight for a bunch of reasons. I mean, I would think that they may have been trying to pull some video cam and footage and surveillance footage of maybe bars or restaurants so they can see if they see the operator drinking in that establishment, how many drinks he may have had. And then you're also dealing with the driving in the sense of certain ring cameras and surveillance cameras along the way to the accident crash scene, and they can see how he was operating the motor vehicle. So they want to obtain that evidence. They want to get that evidence before it gets destroyed, before it goes away. Yes, it's not unusual to keep it tight-lipped.
And how much does it affect the analysis if police say the driver stayed on scene, was there when officers arrived? From a legal point of view, you can also say that he turned himself in rather than being arrested or taken into custody immediately when that warrant, the arrest warrant was issued. How does that affect everything?
Well, it's a big deal because remember, if you leave the scene of an accident, at least in our state in New York, and I'm sure Florida has a similar statute, especially with a fatality, that's a charge in and of itself, despite you could have been sober, impaired, intoxicated. So that's important. And the other component of that is when you leave the scene, there's this consciousness of guilt charge, which a jury can hear if it goes to trial. And it's a really damning piece of evidence where the suggestion is, hey, you left because you did something wrong, i.e. intoxication.
That's a really, really good point. But let's go back to the big question. Now break it down, because the big question that we want to get into, what was the delay? Because if you read from the sheriff's release, it said, quote, Park was transported to a local hospital where his blood alcohol level was drawn. The results showed a BAC, blood alcohol content, of 0.107, well above the legal limit. After a thorough investigation and in coordination with the state attorney's office, JSO detectives obtained a warrant for Park's arrest. So, to truly understand why this happened, the severity of this case, how this all played out, I want to go page by page through the arrest and booking report. And the details that are documented by investigators are quite extensive. They paint a pretty clear picture of what they say happened the night of the crash. So I want to start with the crash itself. According to the report, quote, on May 16, 2025 at approximately 8:28 p.m., Logan F. Park was the driver of a 2009 Honda Civic traveling eastbound in the 4100 block of Bay Meadows Road, Jacksonville, Florida. Mitchell Patch had left Wicked Barley Brewing Company and was walking northbound across Bay Meadows Road to where his vehicle was parked. Mr. Patch was carrying his son Everett Patch while crossing the roadway. And then the report gets very graphic in detailing the force of the impact. And I'm going to read it not for sensational reasons, but because I think it's important from a legal point of view to understand how fast the defendant was allegedly driving and what he may have been doing. Quote, Mr. Patch and Everett were struck by the Honda while in the eastbound lanes of Bay Meadows Road, causing them to strike the hood, then vaulting over the roof of the Honda before coming to rest on the roadway. Both Mr. Patch and Everett were killed as a result of being struck by the Honda. The impact caused Mr. Patch's left leg to be severed below his knee. Mr. Patch suffered head trauma, multiple abrasions, and broken bones as a result of being struck by the Honda and subsequently tumbling along the asphalt roadway. Everett was severed in half at the waist as a result of being struck and suffered head trauma due to striking the roadway. And the report also measures exactly how far they were thrown. And again, apologies in advance because this part is very tough to hear. It's very disturbing. It reads, quote, based upon roadway evidence, Mr. Patch traveled approximately 209 feet from point of impact to point of final rest. Everett's torso traveled 265 feet, while his lower extremities traveled 305 feet from the point of impact to point of final rest. Completing mathematical calculations based upon this information, your affiant believes the Honda was traveling between 58 and 64 miles per hour at the time it impacted Mr. Patch and Everett. The speed limit for Bay Meadows Road, where this crash occurred, is 45 miles per hour. So, Michael, aside from how awful that is and how graphic it is, from a legal point of view, and we're starting to get a sense of why it may have taken so much time for an arrest warrant to happen, what are you taking away from those statistics?
Yeah, again, in our county here in New York State, in Suffolk County, and I think most jurisdictions, initially you're dealing with a driving while intoxicated charge, and that's something somebody can be arrested for on the spot. Now, clearly there are aggravating factors here that they would not have known at that very time, including the blood alcohol content, including the speed of the vehicle, potentially the failure to brake at the time of impact. All of these things may lead to the felony charges, vehicular manslaughter, aggravated vehicular manslaughter, which may have aggravating factors. But again, I don't have an answer as to why he wasn't arrested at the scene.
But you can see maybe how it's supporting DUI manslaughter, which I imagine is this kind of reckless standard, right? If you're driving that fast and it severs the body, right? You're talking about this. There could be no reasonable explanation or defense for this, right? I mean, the faster he allegedly went, the impact, it paints him in a corner of what he can argue.
Yes and no. So here's the thing. There's going to be common law observations, which is slurred speech, strong smell of an alcoholic beverage, unsteady on your feet, red glassy bloodshot eyes. But the intoxication is also going to be corroborated by the blood alcohol content. And let's remember, that's something that's normally done, and I think in this case was done way after the actual impact in the operation. And that's a .10. If you go back in time now, the statute says in Florida, .08 at the time of operation. So from a defense standpoint, what can they argue? They can always argue this absorption defense, where you try to extrapolate and actually bring the motorist under the legal limit of .08 at the time of the operation and the time of the accident.
But that's the key word there is accident, right? They are going to try to argue that this was just a tragedy. This was a tragic accident that, I mean, they can't argue causation. And I hate to say it, but from a prosecutor point of view, at a trial, you have to prove every element, including that somebody died and that the defendant caused the death. So they have to get into these details for a jury. But I do imagine they're going to say, I don't know, all the factors there, maybe the lighting, nighttime, who was crossing the road when, how do they, again, I'm imagining that's what they're going to have to say. It was just a tragedy, right?
Yeah, from a defense standpoint, and I don't know all the particulars, Jess, but yeah, if it's dark out and if the victims were wearing dark colored clothing, and if, for instance, he had a green arrow and he wasn't in a crosswalk, but here they're in a crosswalk. And again, the point of impact in terms of the speed at that point, these are all things that are going to be very important. But the causation part is a big thing, and that's what you just mentioned. And it has to be because of his operation that's what caused the death. And what the defense would argue, obviously, is, negligence is one thing, a criminal standard is another. And it was just an accident as opposed to it happened because of his intoxication.
Well, I will also tell you, Michael, that the report also lays out Logan Park's own statements to authorities and medical staff, or parent statements, and the timeline is really important here. So here's how it unfolded. Immediately after the crash on May 16th, Park apparently stayed at the scene and spoke with first responders because according to the report, it reads, quote, Mr. Park stated he hit something but did not know what it was. He estimated his speed to be between 35 to 45 miles per hour at the time of the incident. While speaking with Detective Prevent noted that Mr. Park's pupils were dilated, but he did not detect any other signs of impairment. Detective Prevent asked Mr. Park if he was willing to consent to a voluntary blood draw, to which he refused. And even after a hospital blood draw, the toxicology report came back, quote, per the FDLE laboratory report authored by crime laboratory analyst C. Siegel, Mr. Park had a blood alcohol content, BAC, of 0.107 plus 0.009 grams / 100 milliliters of blood. Michael, legally speaking, what do you take away from that statistic and his alleged statements?
So you just bridge the gap for us, Jess, because what you have here is you have on-site observations, and they're not observing the typical signs of intoxication or impairment. So I think the delay was really all about, let's get the blood alcohol level, which now we know is a 0.10, at some time subsequent to this accident. And what I'm certain they would have done is now try to backtrack and see where he was drinking, how much he had, to now establish that at the time of operation, we're going to argue as a prosecution, he may have been a 0.10 at the hospital. He was much higher at the time of operation. Because again, you're going to have to fight that inconsistency, because now the observations from the detective don't corroborate impairment or intoxication.
But his statements, right, like him saying he was going, obviously their statistics would say he was claiming he was going much slower than he actually was or allegedly was, and him not wanting to consent to a blood draw. Can that be used against him, and how so?
Yeah, sure can. So not consenting to the blood draw, that's what we call a refusal. And that's important because, again, that goes to the consciousness of guilt. And there's a pretty strong charge to the jury that you're kind of hiding something. And if you weren't impaired or intoxicated, you would give that blood. In terms of, I didn't know what I hit, we hear that often. And it really has to be corroborated by the facts at that time. Again, if the lighting is pretty good and the clothing of the victims was lighter, that's going to be a tough defense for the defendant.
Now, this report also references the field study that was conducted by investigators, and it reads, your affiant and Detective Jesenek conducted a field study of the area where this crash occurred. The field study indicated that the pedestrian would have been able to see headlights of the vehicle for the length of the stretch of Bay Meadows leading to the crash. From the driver's position, the pedestrian could have been visible from a distance of approximately 400 feet, although your affiant notes, I was able to see Detective Jesenek at this distance because I was expecting him to be in the roadway and was looking in the general area where he was expected to be. So, in other words, it seems like this wasn't a dark blind spot situation, that the pedestrian was theoretically visible, right, Michael? I mean, first of all, again, now we see why it took some time. They're kind of almost doing a crime scene reconstruction here. But how does that affect it?
Yeah, I mean, if it's clear that you can see from a distance from the operator of the motor vehicle, that's going to be an important factor because it's something I should have seen. And the reason I didn't see it is because of my level of intoxication. But let's take the flip side. My understanding is the victim also was coming from a bar/brewery. So I think his blood alcohol content from the ME's office would have been significant for both the prosecution and the defense, because if he is intoxicated and walking in the roadway while the car is oncoming, the defense is going to argue that it's attributable to him to some extent.
Now, finally, this report lays out Park's alleged actions leading up to the crash. This is important. Quote, Lieutenant Gonzalez stated Mr. Park told him the crash wasn't his fault and that the pedestrians shouldn't have been crossing the roadway. Mr. Park told Lieutenant Gonzalez that he had been looking down prior to striking the pedestrians. However, He never said what he was looking at, nor how long he had been looking down. Okay, Michael, let's talk about this. First thing I think about, and I don't know this for sure, is were you looking at your cell phone, right? And if that's the case, can the cell phone data tell an investigator that he was searching, looking, Googling something, whatever it might be? What can it?
Absolutely can. And that's a big thing, Jess, and it's a great point because one of the first things that investigators on these vehicular crimes want to do is get access to the operator's cell phone and see if they were on searching the web, texting on their phone without being hands-free, because obviously that's going to distract the operator. And in many states, that's another aggravating factor to try to prove the vehicular manslaughter cases.
I also wonder if it's going to be a challenge for him and his defense team if they go forward with this, and I don't know that they will, but if they go forward with this, putting potentially the impetus, the blame on this father and child, right? And I think when I laid out what happened to them, what happened to their bodies, that's a difficult road to go down, no?
It is. It is. And listen, as a defense attorney, you have to concede certain things, and you really got to obviously express the sympathy factor and get a jury that understands this happened, but we need to really focus on the criminality part or lack thereof. And you really have to do a great job in your voir dire with the jury to try to distinguish and separate the jurors who can really focus on the law and put aside sympathy.
Look, I think that if all this evidence is presented to a jury, it's really bad evidence for him. Having said that, in your experience, does he have ways of challenging the accuracy? Does he have ways of challenging that, crime scene reconstruction? Does he have ways of challenging the blood alcohol content, right, the toxicology results successfully?
Yes, the answer is yes, and that's something we breached on earlier. In terms of blood alcohol level, and this is something we who do DWIs every day focus on, which is the law doesn't permit you to, or doesn't prohibit, I should say, somebody from being drunk in a police precinct or a hospital. That's not what the statute said. It's about time of operating that motor vehicle. So again, if we go back in time and you have a blood alcohol content of 0.10 at the hospital, the issue really becomes what was it at time of operation? And if you can get an expert and get a toxicologist and extrapolate backwards and put the motorist under a 0.08, you're left with negligence, and now it defeats the entire criminal statute.
Now, beyond the legality for a second, beyond the investigation, beyond the charges, there is the human side of this tragedy, and I want to leave it with this. There is a GoFundMe that was set up for Mary, this is Mitchell's wife, and it shares just how devastating this loss has been. And we're going to put it up here if you want to contribute. The page reads, "This devastating loss has left her and her family heartbroken and now face the immense challenge of grieving while trying to manage any financial burdens that come with such a tragedy. As we come together to support Mary, we hope to relieve some of the financial pressures, including funeral costs, medical bills, and any unforeseen expenses during this difficult time. The funds will directly go to Mary to assist her navigating this heartbreaking situation." And as for Logan Park, he is scheduled for an arraignment on December 3rd. Michael Brown, thank you so much for taking the time. Really appreciate it.
Jess, my pleasure. Thank you for having me on.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.